Breaking news tonight, and this is not a drill. Something has fractured at the very core of American power, and the consequences are unfolding in real time. The machinery of the presidency, long assumed to be resilient under any strain, is no longer operating normally. The West Wing, the nerve center of the most powerful office on Earth, has entered a state of enforced paralysis. Doors are locked, access is restricted, communications are monitored, advisors are barred. And at the center of it all, President Donald Trump finds himself abruptly, dramatically isolated. Over the last 48 hours, an extraordinary chain of events has unfolded. Events that many inside Washington once believed were institutionally impossible. A federal judge's emergency order has triggered a cascading lockdown inside the White House, severing the president from key figures in his inner circle and plunging the Capitol into a constitutional crisis unlike anything seen in modern American history. This is not politics as usual. This is the system activating its emergency brakes. What began as a sealed legal maneuver, quietly initiated and carefully contained, has now erupted into a full-scale interruption of executive authority. An emergency injunction issued late at night by a judge in the D.C. Circuit Court imposed sweeping restrictions under the justification of national security and judicial protection. The ruling orders President Trump to immediately cease all direct and indirect communication with a defined group of advisors. Individuals now formally designated as potential witnesses or co-conspirators in an expanding federal investigation. The names listed in the order were once synonymous with the president's power structure: Rudy Giuliani, Steve Bannon, Jared Kushner, figures who once moved freely through the West Wing, who shaped policy, messaging, and strategy at the highest levels, are now legally untouchable. They are barred from entering the White House, barred from calling, barred from texting, barred from relaying messages through intermediaries. Even indirect contact, through staff, attorneys, or informal channels, carries immediate legal consequences. The wall around the president is no longer symbolic. It is real, enforced, and absolute. This order did not emerge casually, and it did not arrive quietly. It followed an emergency court session convened after explosive whistleblower testimony leaked to the press. Those disclosures allege the existence of a shadow decision-making network operating parallel to official government channels, an informal but influential structure through which policy influence, financial maneuvering, and foreign contacts were allegedly coordinated beyond formal oversight mechanisms. According to the testimony referenced in the ruling, certain advisors operated outside documented processes, bypassing traditional safeguards and leaving limited paper trails. The judge's order cites a clear and present danger to ongoing Justice Department investigations, warning that continued contact between the president and implicated figures could irreparably compromise evidence, intimidate witnesses, or obstruct enforcement actions. The language used by the court is blunt. This is not cautious jurisprudence. It is not hedged. It is not exploratory. The ruling signals unmistakably that judicial patience has expired. The tone is final. Inside the White House, the impact was immediate and disorienting. Appeals were filed in rapid succession throughout the day by the president's legal team, each challenging the scope, timing, and authority of the order. Each was rejected with striking speed. By midnight, the injunction was active. By dawn, enforcement had begun. Secret Service agents were repositioned at key access points within the West Wing. Federal personnel assumed monitoring roles. Entry lists were rewritten. Communications infrastructure was rerouted through supervised channels. Advisors attempting to enter were turned away without ceremony. Staffers arriving for work walked into a building that felt fundamentally altered, stripped of its usual rhythm, stripped of its certainty. Meetings disappeared from calendars. Briefings were canceled without explanation. The press room sat empty, its podium untouched, as if the daily ritual of presidential authority had been paused. The familiar cadence of statements, spin, and response vanished. The paralysis is not symbolic. It is operational. The West Wing now functions at a fraction of its normal capacity. Its usual machinery is jammed by legal constraint. Emails pile up unanswered. Policy memos remain unsigned. Phones ring, then fall silent. Staff members drift through corridors uncertain of who holds decision-making authority or whether decisions made today will survive legal scrutiny tomorrow. One senior official described the atmosphere as suffocating, a building full of motion with nowhere to go. This is what happens when confidence in the executive collapses all at once, not through an election, not through legislation, but through enforcement. Outside the gates, Washington vibrates with tension. Reporters crowd the perimeter. Cameras remain trained on dimly lit windows, where the president is said to be pacing alone. The familiar torrent of late-night social media posts has stopped, silenced by legal restrictions tied to the investigation. Insiders whisper of fury, disbelief, and a growing sense of entrapment. Trump, known for his instinctive, deal-driven leadership style, now finds himself boxed in by procedural walls that no amount of rhetoric can breach. The courtroom has replaced the rally. The statute has replaced the slogan. What makes this moment uniquely destabilizing is not just the severity of the order, but what it represents. The judiciary is signaling, without ambiguity, that the presidency is not an impenetrable shield. The ruling explicitly accuses the administration of willful obstruction and warns that any violation will trigger immediate contempt proceedings. The consequences outlined are extraordinary: asset seizures, account freezes, criminal referrals for intermediaries, federal marshals placed on standby. This is not a warning shot. This is the sound of the guardrails locking into place. As the story breaks, its effects ripple outward with astonishing speed. Trade negotiations stall as foreign counterparts seek clarity on who can commit the United States to binding agreements. Infrastructure planning freezes as agencies hesitate to authorize projects without clear executive backing. Deputies scramble to fill gaps left by the absence of senior advisors, only to discover their authority is limited, provisional, and subject to reversal. The West Wing, once projected as a fortress of executive will, now feels like a sealed bunker, its occupants waiting for instructions that cannot legally come. Power has not merely weakened, it has been interrupted. The political response is equally telling. The silence is the story. Public statements from Republican leadership are emerging, but they're stripped of their old muscle. No chest-thumping defenses, no reflexive rallies around the flag. Instead, the language is cautious, almost clinical. Carefully calibrated phrases replace loyalty. If the allegations are accurate, if the courts determine, due process must be respected. Each word chosen not to defend a person, but to protect a position. This is not how past crises sounded. In earlier moments of pressure, unity was immediate and unmistakable. Leaders closed ranks, messaging snapped into alignment. The party spoke with one voice, projecting confidence even when facts were inconvenient. That instinct is gone. What's replaced it is hesitation, and hesitation at this level is never accidental. The absence of immediate, unified backing speaks louder than any press conference ever could. No emergency caucus appearance, no coordinated media blitz, no senior figures rushing to frame the conflict as an existential threat. Instead, there's a vacuum. And in politics, vacuums don't last. They get filled with calculation. Behind closed doors, that calculation is already underway. Strategists are sketching scenarios on whiteboards and legal pads, quietly gaming out outcomes that were once unthinkable. How long can this last? What happens if enforcement escalates? What happens if it doesn't? What is the cost of standing too close if the situation worsens? And what is the cost of stepping away too early? These aren't moral questions, they're survival ones. This is the inflection point where ideology begins to bend under the weight of self-preservation, where loyalty stops being automatic and starts being conditional, where proximity to power becomes a liability instead of an asset. Allies begin to calculate distance. Not publicly, not yet. But the signs are there. Fewer appearances, softer language, statements that praise past accomplishments while conspicuously avoiding the present moment. Support that comes with caveats. Silence where certainty used to be. The language shifts first. It always does. Words like "we" quietly disappear, replaced by "the administration." Responsibility becomes abstract. Ownership dissolves. Even the tone cools, as if emotional detachment itself is a form of insurance. The room grows colder. Staffers notice it. Donors feel it. Media figures sense it before it's ever acknowledged out loud. The gravitational pull that once drew everyone inward begins to weaken, and orbits start to drift. No one wants to be the last person defending a position that may soon become indefensible. This doesn't mean abandonment, at least not yet. It means optionality. Leaders are preserving room to maneuver, keeping escape hatches unblocked. They are watching the legal and political currents closely, waiting to see which way the momentum breaks before committing fully in either direction. In moments like this, hesitation is not confusion, it's strategy. What makes this especially destabilizing is that it's happening quietly. There are no dramatic resignations, no fiery floor speeches, no public schisms, just a gradual thinning of the line. A sense that the collective shield has been lowered, even if no one has formally walked away, and that quiet recalibration can be more damaging than open rebellion, because power depends on perception, and perception shifts long before reality does. Once party leadership starts speaking in hypotheticals instead of certainties, the signal is unmistakable. Confidence is no longer assumed. Outcomes are no longer guaranteed. The future is no longer something to charge toward, it's something to hedge against. This is how political abandonment begins. Not with betrayal, but with distance. Not with denunciation, but with restraint. Not with anger, but with calculation. By the time it becomes visible to the public, the decision-making has already moved on. And as the language cools and the silence deepens, one truth becomes harder to ignore. When allies start preparing for life after a crisis, they're no longer convinced the crisis will pass cleanly. They're preparing for what comes after. What is unfolding is not simply a legal battle, but the early stages of political abandonment, the quiet recalibration that occurs when power appears to be slipping. No one wants to be standing too close when the structure finally gives. As night falls again over Washington, the West Wing remains locked in limbo. Lights burn late in offices with nothing to announce. The building stands intact yet inert, a monument to stalled authority. The question haunting the Capitol is no longer whether this crisis is real, but how far it will go. Because once the system moves into enforcement mode, it rarely reverses course. What began as an emergency order has now crossed an irreversible threshold. The legal cascade is no longer theoretical. It is active, precise, automatic. Once triggered, it moves forward with the cold efficiency of a machine that does not pause to assess intent or context. Symbolism has dropped away. What remains is enforcement. At the center of this cascade is contempt. Federal statutes governing judicial orders are intentionally unforgiving. They are designed this way to prevent hesitation, negotiation, or delay. The moment a prohibited action occurs, one call, one message, one indirect signal, the system does not ask why. It does not weigh motives. It responds. Detection equals activation. Contempt provisions embedded deep within federal procedure ignite instantly when violations are identified. There is no discretionary buffer, no warning shot, no informal resolution. Once the threshold is crossed, obligation replaces choice. Enforcement becomes mandatory, not strategic. This is why compliance is no longer a matter of preference or defiance. It is the only path that avoids escalation. Every decision now exists within a narrowing corridor. Stay inside the lines, and the situation remains contained. Step outside them, even accidentally, and the consequences compound immediately. One infraction obligates the next response. One refusal triggers the next mechanism. The chain reaction is built into the system itself. Attempts to test the boundaries are not merely discouraged, they are punished. Circumvention has been anticipated and preempted. Intermediaries are not loopholes, they are liabilities. Encrypted channels are not shields, they are evidence. Informal backchannels do not soften enforcement, they expand its reach. Anyone who touches the message becomes part of the transmission, and anyone who participates shares exposure. This is how containment works. It does not rely on trust, it relies on structure. Inside the White House, the effect is immediate and disorienting. The familiar hum of constant communication has vanished. Phones ring less often, messages go unsent. Conversations stop mid-thought as staffers calculate risk before finishing sentences. Silence settles not because nothing is happening, but because everything is being watched. That silence is not accidental. It is enforced. Every pathway that once allowed influence, coordination, or reassurance is now a potential trigger. Legal teams review language before it leaves the room. Advisors hesitate before speaking, aware that proximity itself can be construed as participation. Even routine interactions are scrutinized for unintended implications. The result is an environment stripped of spontaneity. And that is by design. The system is not attempting to persuade or negotiate. It is not responding to rhetoric or pressure. It is executing a containment protocol meant to isolate, stabilize, and prevent interference. Emotion has no role here. Urgency does not accelerate relief. Defiance does not inspire flexibility. Containment does not argue. It constrains. Each hour that passes without violation reinforces the walls. Each moment of silence confirms compliance, but that silence comes at a cost. Decision-making slows. Authority fragments. Confidence erodes as uncertainty fills the gaps where communication once flowed freely. Power, when isolated, behaves differently. Without constant feedback and reinforcement, it becomes cautious, reactive, and inward-facing. The outward projection of certainty fades, replaced by internal calculation. Every move is weighed not just for political consequence, but for legal survivability. This is how paralysis takes hold. Not through dramatic confrontation, but through procedural pressure applied evenly and relentlessly. The system does not need to win an argument. It only needs to keep the rules intact long enough for outcomes to solidify. And those outcomes are cumulative. One missed call leads to one delayed decision. One delayed decision creates a vacuum. That vacuum invites speculation, hesitation, and second-guessing. Over time, momentum drains away, not because authority has been formally removed, but because it can no longer move freely. This is the danger zone of enforcement, not collapse. Containment. The machinery continues to operate, but at reduced capacity. Functions technically remain intact, yet their effectiveness diminishes. The structure stands, but its influence weakens. And once that shift becomes visible, it feeds on itself. Silence breeds uncertainty. Uncertainty breeds caution. Caution breeds inaction. From the outside, it can look like calm, like restraint, like discipline. But inside, it feels unnatural, stifling. A building full of people waiting for permission that cannot be safely given. The system does not care how this feels. It was not designed to. It was designed to prevent interference, protect evidence, and enforce boundaries when all other deterrents fail. And once activated, it rarely reverses course quickly. Containment is not a phase. It is a condition. And as long as the cascade remains active, every actor inside the system understands the same unspoken truth. The safest move is no move at all. Behind the scenes, institutions align in rare unison. The Justice Department, the FBI, and court-appointed monitors coordinate enforcement with a clarity that suggests long preparation. Emergency appeals filed by the president's legal team are dismissed with clipped language that leaves little room for interpretation. Higher courts decline intervention, citing the narrow and temporary nature of the order, even as its practical impact expands by the hour. The legal strategy shifts, from aggressive counterattack to damage control, from overturning the ruling to managing its consequences. That shift alone speaks volumes. Inside the administration, the mood turns brittle. Staffers accustomed to operating on instinct now wait for written guidance that arrives slowly, if at all. Acting deputies attempt to triage urgent matters, but their authority is constrained by the same legal fog surrounding the president. Every decision is scrutinized for risk. Every action is second-guessed. The machine that once moved at breakneck speed now crawls, its gears grinding under uncertainty. The word most often whispered in hallways is not defiance, but exposure. Leaks intensify, not dramatic revelations, but methodical disclosures. Anonymous sources describe an administration unraveling from the inside, confidence eroding as legal walls close in. These disclosures further weaken public trust, reinforcing a narrative of collapse that no amount of messaging can fully counter. The information environment fractures into parallel realities, each side consuming a different version of events, yet both sensing that something foundational is shifting beneath them. The escalation phase produces predictable reactions. Loyal surrogates outside the immediate blast radius issue statements of defiance, promising countermeasures and vowing to fight. Emergency filings appear in sympathetic jurisdictions, seeking relief that never comes. Internal memos circulate, asserting authority that no longer carries weight without full presidential backing. Enforcement now has momentum, and momentum is difficult to stop. International reaction follows a familiar pattern, cautious at first, then increasingly uneasy. Allies issue measured statements emphasizing stability while quietly pressing diplomatic channels for reassurance. Adversaries observe with thinly veiled interest, their state media amplifying images of American dysfunction. The global chessboard does not pause for domestic crisis. Rivals probe for advantage where certainty once deterred them. This is how power vacuums announce themselves, not with alarms, but with opportunistic movement. As hours stretch into days, the political landscape shifts decisively. Former allies hedge openly, praising past accomplishments while distancing themselves from present turmoil. Party leaders convene behind closed doors, weighing loyalty against longevity. Internal polling circulates, showing erosion among independents and fatigue even within the base. The calculus changes. Defending the president at all costs no longer feels like a winning bet. Silence becomes strategy. Markets respond with nervous volatility, pricing in prolonged gridlock. Federal agencies slow non-essential actions. Governors assert autonomy, filling perceived gaps with state-level initiatives. The center does not hold because the center cannot speak. Inside the Oval Office, isolation becomes psychological. Deprived of real-time counsel, the president cycles between bursts of anger and long stretches of contemplation. Handwritten notes replace rapid-fire directives, but many never leave the room, stalled by legal review or uncertainty over who can act on them. The familiar rhythm of influence, feedback, and escalation is gone. What remains is a solitary figure confronting the limits of power without the buffer of loyal intermediaries. By the third day, containment gives way to acceleration. Appellate courts uphold the ruling with language that leaves little hope for swift relief. Even sympathetic observers concede that intervention is unlikely. The legal machinery grinds forward, indifferent to politics, propelled by procedure. Within Congress, whispers grow louder, drafts circulate, committees prepare. The word impeachment returns, not as rhetoric, but as contingency. No one commits publicly, but the infrastructure quietly reassembles. Public opinion shifts measurably. Approval dips less from scandal than from perceived inability to govern. The base remains energized, but fatigue creeps in. The crisis loses shock value, replaced by dull anxiety. Reports surface of former insiders cooperating with investigators. Loyalty dissolves under legal pressure. Survival eclipses allegiance. As night falls again, the White House glows against the darkened city, a familiar silhouette imbued with unfamiliar stillness. This is no longer a story about one man or one ruling. It is a stress test of constitutional architecture, a live demonstration of checks and balances under maximum strain. The system shows resilience in its ability to act, and fragility in the disruption that action causes. Three paths remain visible: compliance that resolves the crisis, paralysis that erodes legitimacy, or historic confrontation that redraws executive power. None lead back to normal. The situation is not stabilizing, it is accelerating, and the world is watching.